Right, good evening, everybody. Welcome to the Law Committee meeting for August 24th, 2022. I'm Vicki Plotsky, and sorry I'm a couple minutes late. Majority Council, would you like to take roll?
Sure, Madam Chairwoman. Ms. Plotsky,
Present.
Cunningham, Bergdorf,
Here.
Feeney,
Here.
Kuhn,
Here.
Mayo,
Here.
Peter,
Here.
Ricard,
Present.
and Whalen.
Here.
8 present, Madam Chairwoman.
Great, thank you very much. Is there a motion for the minutes from last meeting?
Motion.
Wow, lots of motions. Thank you. Matthew Peter, first and a second. Mr. Ricard, great, thank you. All in favor?
Aye.
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 Thanks, everybody. Now, items 2, 4, 5, 6, 7, 8, and 10 are tabled either at request of sponsor or pending public hearing. So let's hop to item number 3. Ms. McLaughlin, I believe you're here to speak about the salary disclosure law, local law. This is to go to public hearing.
Yes, I just want to say that I have appreciated the discourse that has taken place over the last 2 months around this legislation. And I do believe that we've reached a point where we are ready to go to public hearing. And I would hope that all questions and concerns have been addressed at this point. And I ask for your support tonight in doing just that, moving it out of committee for public hearing.
Great, thank you. This has been discussed quite a bit. This is just going to public hearing. Mr. Peter, your hand is raised.
Yes, Madam Chair, thank you. I'm in full support of this, and just, I was pleased, and I talked to council before, that this also was going to be required of the county government and things like that. The amount of individuals who have applied for jobs in such a large range are not even disclosed, and who have gotten frustrated and used their limited time to advance themselves only to get the runaround, especially those who use public transportation and things of that nature. This is really, really, really important. I'm sorry. Yeah, and that is exceptionally important for me. So I'm, for this. I would like to move it to public hearing. I'd like to be added as a sponsor. And with that, when there is, no more questions, I would make a motion for that. I know Mr. Bergdorf has his hand raised, but, thank you, Member McLaughlin, for putting this forward.
Thank you, Mr. Peter.
Thank you, Mr. Peter. Mr. Bergdorf.
Thank you, Madam Chair. Carolyn, I hate to ask questions at a late period of time, or maybe these are questions which will come out at a public hearing. I'm certainly going to vote to send this to public hearing tonight, as I think all of our local laws should. But I was a little unclear how this gets enforced, because it in one section it talks about the civil cause of actions, which means it could be self-policing by complainants who feel as though they have been wronged. And in another section, it talks about the affirmative action officer. And I don't know if that's the Albany County affirmative action officer, but we've got, 40, 50, 60,000 businesses in Albany County. And I'm not quite sure how the enforcement's going to work.
Mr. Collins?
Yeah, I can
Sorry.
handle that if you want, Carolyn, or Chairwoman Plotsky. So it is the Albany County Enforcement Officer or Affirmative Action Officer. That dates back to the original or the current version of the Human Rights Law for Albany County, which came out in 2013. It does not provide a civil cause of action or a private cause of action for anybody who is not a current employee of a business. It's cutting that out. That would apply to all the other sections of the human rights law, but not this one. It just seems to be almost too much of a burden. We don't want to burden the courts. We're not trying to hurt employers. We're just trying to level the playing field a little bit here. For compliance or enforcement, people make mistakes. If somebody's aggrieved by this, saying, hey, you made the mistake, the notice is sent to the Human Rights Commissioner or the Affirmative Action Officer. If they find that there is failure to comply, they send a letter with opportunity to cure. Put the salary disclosure in there. And then everybody's made whole and we're done. If businesses continue to refuse, that's when the enforcement would actually go into place, the system of fines. But I don't expect any income from this because it's very easy to just comply with it, to put a salary range or an hourly rate, and it's a good faith requirement that if you reasonably believe and have good faith that that is the range of the salary, just comply and post it on the listing.
Yeah. Oh, okay. I appreciate that. I understand that when you briefed our staff, you talked about it would only apply to people who are within the corporation.
Right.
I didn't see that language in there, and maybe someone could point
It's
that out.
for I'll send it to you in an email. And
Okay, that's fine. Now, employers. So Albany County is going to abide by this, right?
we already are required to abide by the 2015 law.
Is the state legislature, the Court of Appeals, the judiciary,
The ones who
the town of
supersede,
Colony, the city of Albany, because they're municipal corporations. It says any corporation.
the ones that supersede our authority, like the state, I don't expect it to be them to be bound by it, but for the municipalities, I don't see how this is an issue for a municipality to comply with. I think most of them already do because of all the civil service requirements of them.
Mhm.
Well, I mean, there are a number of confidential positions in municipal government, and they don't generally give a salary range. But your position here is that it includes governmental entities below the county. So the city of Cohoes, the village of Green Island, town of Colony, we're putting this mandate on them as well.
The mandate already exists for all the other portions of the human rights law, and it has since 2013.
Okay, well, I'm just trying to clarify who this actually affects. So it's not just private. It's public and private, junior to Albany County, but we can't make that requirement upstream of a larger division of government or something like that. Okay.
All right.
The sunset clause language that we just got, a couple hours ago. It says if a state law is adopted. Okay.
Yep.
Does that mean signed by the governor?
It could. If this law is passed, the Department of Law will ultimately determine that answer. They would take over the reins of defending all officers and employees of the county and all laws of it. But I mean,
well, let me tell you.
I know they have an extended effective date.
Yeah, well, that's why I'm saying. I'll tell you why I think that's important. We have a 90-day effective date, and we don't seem to have any mechanism for rules or regulations or advisory opinions or any educational component, which the state law does. First of all, it doesn't go into effect for 270 days from when it's signed. And then there is an educational component before it starts enforcement. So if Governor Hochul signs the legislation on November 1st, ours just goes away.
I feel, if you're asking me, I would say essentially yes. But
Okay.
ultimately, the Department of Law would have to opine on that.
Okay. Well, my concern in all of this type of legislation is that even for whatever period of time it is, anything that Albany County does puts Albany County businesses at a competitive disadvantage. And I'll just make up a little example for you. If you're an HVAC company and you are advertising that you need HVAC technicians and the range is $30 to $40 an hour, that is essentially proprietary business information. So your competitor from Schenectady County or Rensselaer County or Saratoga County can very quietly, without saying or doing anything, change their compensation to $35 an hour to $45 an hour. So that's why I'm really hoping. I have issues with us as one county putting, constraints, limits, and limitations on just businesses in our county. So I am hoping that if this were to happen, that the state law will go into effect and we don't even have to get into this.
I could appreciate that. You use the term, you're putting businesses at a competitive disadvantage. I would say we're putting our citizens at a competitive advantage and look at it through that lens. I think that the citizens of the county are the most important aspect, but we can agree to disagree.
So I would like to, we have 3 more hands raised on this, and we unfortunately have a half-hour meeting. So I'm sorry, Mr. Bergdorf.
No, I appreciate it. Thank you. I'm done. I've made my
All right.
observations and asked my questions and hope maybe we'll get some answers at
And
the
this-
public hearing.
Yeah, this is just going to public hearing. Mr. Kuhn, please.
Sure. Yeah, I raised some issues about this proposed legislation over the last couple weeks or last couple months, I guess, at the meetings. Ultimately, for the reasons that that Mr. Peter and also Council Collins have mentioned, I think this is a law that's really about sort of leveling the playing field in the employment market between employers and employees, and making sure that nobody is at an unfair advantage in that process. The legislation, I think, has gone through some tweaks and some revisions over the last couple of months. I know I've talked to staff a little bit about that. Ultimately, I think the finished product here is a little clearer and a little fairer, and I think also probably a little bit more enforceable, which is ultimately the objective. So I think it's a pretty effective piece of legislation, and I thank Ms. McLaughlin for proposing it, and I'd be happy to be added as a sponsor as well. Thanks.
Thank you, Mr. Kuhn. Very much appreciate that. Mr. Peter.
Yes, I won't take up too much time. As I think all the points were made, I would just amend my motion, Madam Chair, or make a separate motion if that's how Majority Council feels, to change the public hearing date to September 27th. I believe it's just a slight error, and we just want it to be consistent. So however council wants us to do, whether it's amending my motion to move it to public hearing with the amended date, or amend the date and then move it to public hearing.
Yeah, I think we did 2 separate motions. So a motion to amend the date to the 27th. Okay, can I have a second on that?
Second.
Thank you, Mr. Kuhn. And all in favor of amending the date to the September 27th?
Aye.
Aye.
Any opposed? Nope. Thank
Yeah.
you. And now, Mr. Peter.
Yes, and then I would like to amend my motion to reflect moving this to public hearing for the amended date of September 27th, although I see Ms. McLaughlin has her hand, so I apologize.
Oh, no, you go right ahead.
Sure.
I just wanted to comment after. Go ahead. with your motion.
Okay, is there a second on Mr. Peter's motion?
Second.
Thank you, Mr. Feeney. All in favor?
Aye.
Aye.
Any opposed? Nope. Thank you, Ms. McLaughlin.
Yes, I just wanted to again say thank you all for the spirited discussion we've had on this. And I hope that the discussion with all the questions that have been raised, that people have gained greater knowledge. And so that as we go to the public hearing, some of these issues can be further discussed and flushed out, and other people will get part of that education that is so important before we can move forward with this. So thank you again, all who gave us an opportunity to delve into the true meaning of the legislation. Thank you so much. I appreciate it.
Thank you, Ms. McLaughlin. All right, on to our last item, item number 9, public hearing for local law H concerning access to healthcare facilities. Lynn, Ms. Makakis, where are you? There you are. Would you
I'm
like to
here.
say a few words?
Sure. H is for healthcare access, and if you looked at it, you would see that it prevents people from being harassed as they come and go from healthcare facilities for treatments or procedures. It designates a 50-foot buffer zone, if you would, around healthcare entrances in which people cannot be harassed or blocked in any way. It protects everyone, all kinds of people at all kinds of healthcare centers with no exceptions. And it sends a clear, strong message that it is the right of every county resident to get their medical treatment without anyone bothering them about it. And I feel like this is a basic human right, and I invite you to co-sponsor because I see no reason that it shouldn't go out with 39 sponsors on it. And I hope you'll move it this evening to public hearing.
Thank you very much. Are there any questions? And again, this just goes to public hearing. Mr. Peter.
No questions. I know some of my colleagues do, so fair enough. But when those questions are done, I would like to be added as a co-sponsor and move this. And thank you, Ms. Lakakis, for putting this forward.
Okay, great. We have 10 minutes left. So let's give Ms. Whalen a chance to talk, please. If you don't mind, Mr.
Hi
Berger.
there. Thank you. Yes, thank you. I'll be quick. I just have a few quick questions. So I'm curious. I've read up on these types of this type of legislation, and there's been many court cases across the country and in the Supreme Court regarding these types of prohibitions. And so I was just wondering if the 50-foot buffer zone that we have in this legislation, has that been vetted out legally? Like, because I thought I read a Supreme Court decision might not have upheld a buffer zone such as this. I know there's differences
Yes.
between buffer zones and floating zones, but who has looked at, like, what legal,
Collins has
like,
looked
have
quite a
the-
bit.
So in your travels through through Westlaw, you may have seen Hill versus Colorado, which is 100-foot buffer zone, and the Supreme Court of the United States
that-
upheld that law. And I would also say that although that was in 2000 and 2020, the Supreme Court denied Price v. Chicago certiorari, and that was based on the Hill decision 20 years earlier. So it's still good law. This is 100% based on the language out of Hill and out of Price.
and then what about has the floater
Yep.
been upheld? The 8-foot,
100%
what is
out
the
of-
floater in? Can you
It's
give
out,
me
it's out of the
the
Hill
8?
decision.
So it's 50 feet as the buffer zone is 50 feet, and then the floater zone, which is around the folks, is 8 feet. Is that correct?
Yes,
Yes.
that's for
Okay.
the quiet.
And does that
or the
does that
quiet-
apply to? Does that also apply to the healthcare workers, the
no,
employees
that's-
of the facilities?
Well,
What?
I imagine that the
Sorry.
employees of the facilities are there to help the patients.
I think she means the other way around. If an employee is trying to get in the building.
I'll get you an answer on that off the top of my head.
Okay.
Or what if there's an employee, like, an employee going in and there's no patients around, but they're getting harassed or,
Yeah.
does this apply to them also?
It's anybody,
question.
any person entering or leaving a healthcare facility. It doesn't matter if they're a employee or a prospective patient or anybody else.
And in many circumstances, employees are with patients and vice versa, so.
Right.
It covers
Okay.
covers everybody, children, adults.
Okay. And then, I think that's all I have for right now. Okay, thank you.
Great. Thanks, Ms. Whalen. Mr. Bergdorf?
Yes, once again, I, not being an attorney, I spoke to a couple who had made me aware of at least 2 Supreme Court cases. The one that Pat cited in Colorado, which was upheld, and then one which was specific for a particular type of health facility in Massachusetts, which the Supreme Court struck down. So I understand this is modeled after generic blockage of a healthcare facility. This could potentially, in my mind, limit people's First Amendment rights, whether it's the nurses union that is encircling the front of Albany Med with signs, telling people who are going in that they're scabs and they shouldn't go to work because Albany Med is unfair to nurses. There are other applications where there could be a demonstration within 50 feet of an entrance to a facility. And I'm just not sure that the potential of a 1-year sentence in jail is appropriate for people who may be expressing their maybe unpopular First Amendment opinions.
The way I understand it is they can still have their First Amendment opinions at the 50-foot line, and they can still speak and sing and chant and call people names and be as rude as they would like to be at the 50-foot line. This is the zone in which a person can get past whatever's going out there. Even I've been with nurses in the front of Albany Med and stayed on the sidewalk.
Yeah.
People are, they need to have that bit of time to pull themselves together and get inside without anybody bothering them. And it's pretty clear if somebody tries to hand you a pamphlet or a palm card and you don't want it and you give them, the no sign or imply a no sign, then they are to step away from you. To me, it's not really, just like you can't at the Board of Elections, you have a 100-foot zone and you can't be, it's just a line, and it's not, I don't think that any of those court cases ruled that it wasn't supporting person's First Amendment.
Yeah, I think
there was a lot of research into this before it was put on paper and proposed. And I think that the level of confidence.
I understand that this is somewhat generic legislation that is floating around in various jurisdictions, but there are within the definitions, there are some very subjective terms such as harass. Is somebody chanting, harassing somebody? Is somebody holding up a sign, intimidating somebody?
Paul, harass is defined, and I guess I feel like it covers all the bases. It's been researched, and
okay,
I'm sorry that you can't get behind it.
Well, I hope at public hearing some of the people will address some of these things and illuminate them. Do we have a problem in Albany County right now?
If I may say, we have 3 minutes left, Paul. I'm sorry.
Wait,
Okay.
Could
And
I
have
ask
3 more
another
hands
question?
raised.
I'm sorry, Ms. Whalen, I was before you on this one.
Okay,
Well,
no, go
we're
ahead,
getting a little
sorry.
pushy
I'm
here.
sorry.
Let's keep it short.
I-
Thanks, Mr. Peter.
So just on Paul, my partner is a doctor, one who provides services at both Planned Parenthood and Albany Med. We have a problem in Albany County, Paul. And if we can do laws about aggressive panhandling, if we can do laws on electioneering, we can protect someone's access to healthcare. And it's been carefully researched, and someone's right to protest, which is protected in this, is fine, but they don't have a right to intimidate and impart fear onto healthcare providers or people trying to get healthcare. And to say that we can somehow make calls about people electioneering and make those differentiations, but not for someone intimidating someone specifically getting their health care, in my opinion, is ludicrous. And this has been carefully researched and upheld by the Supreme Court. And I'm very confident in this legislation.
Is that the dog?
I'm sorry, someone just knocked on my door. Someone showed
Oh,
up.
I thought it was Matt's dog who was up with the cat.
You can walk with me to my kitchen. Sorry, Miss Whalen, you're next.
No, I thought that was Matt's dog, and he was saying that the dog wasn't interested tonight. I just thought that was like perfectly on cue. Listen, just because I'm asking questions doesn't mean I'm not behind this or I'm behind it. I'm just asking questions because I want to know these answers to these things. So thank you for letting me ask another question.
Sorry
there
for
are
the
a lot of
disruption.
court cases out there, and hello?
Sorry for
Can you
that
hear me?
disruption. Yes, please.
That's okay. I just want to make sure you can hear me. So I know there are federal laws, like I've done a little bit of research on this myself and I've studied the cases and I know that there's federal laws called FACE, which protect healthcare facilities and actually houses of worship from antagonistic behavior like this. And so
That's
I'm
only,
wondering.
That's abortion healthcare services specifically. This covers all healthcare, and that's what the difference is. So if
I think, oh, so
if a
FACE is
trans
just, that's what
person
I
or
was going,
somebody,
I wanted to,
if you were against vasectomies and guys were going to get a vasectomy or, you know, some
Yeah.
tattoo that is a medical procedure
Or anti-vaxxers.
or anti-vax or any
Mhm.
healthcare things at all. Trans youth, you know, getting hormones. It's like people have a lot of
Okay.
opinions about what people should be doing with their healthcare. It's just not their business, you know.
so FACE just pertains federally to houses of worship and specific healthcare facilities. So this legislation expands it, but I have to ask you a question. How is this different than what we have already in the state? Like there's federal laws that sort of mirror this and state laws, you know, at least in the courts. I've read, you know, the Rochester and Buffalo cases. So
Well-
how is this any
Understood.
different?
Is Patrick, is
Like,
this something you can address
how-
briefly?
Yeah, if
How
it's
are
in
we
Rochester, it's
expand-
in Rochester. It's not in Albany County. I think we should be proactive here and make sure that our citizens are protected.
And how is this otherwise covered by state or federal law?
I know the FACE Act that they're speaking of, that's reproductive care facilities. This is far broader. than
Oh,
that.
this is broader.
I'm not aware of a state.
So
law.
Great.
there's no state laws whatsoever, just court cases. That's it. Is that what you're
There
saying?
are trespassing laws about being on a public property versus private property, but that doesn't always apply either. This gives a full 50 feet, no matter where the door is located, so that people can't be bothered when they're going into a facility. That
Okay.
provides.
We are now over time.
Sorry.
Mr. Grimm,
All right, thank you.
very quickly, and
Yeah,
let's wrap up.
there's just some language. I know, I understand the intent here is just to keep people that are just over the top, away from people who need medical care. But on the definition of harass, it says the term harass shall mean to engage in a course of conduct or repeatedly commit conduct or acts that alarm or seriously annoy another person. Doesn't this criminalize someone for being annoying?
That's
How do you define seriously annoy? Because
Mr. Collins, I think,
That's a pretty standard definition of harass from. state.
Yeah, harass is also defined in the penal law, and it's defined almost exactly that same way. And there's a lot of case law on what exactly constitutes harassment and what does not. So it's actually very fleshed out.
But it isn't though. It specifically says seriously annoy another person. That's
What currently on the book for all harassment.
Yeah, that's what.
that's my problem with all the laws then, because if you seriously annoying someone is not a crime.
Well,
So it's
listen,
not
that's
an
just
issue
a
unique
that's
to
just a
this
recipe
law.
for anarchy. Every law, you can piece the words apart at some point and say, hey, this is subjective. I find this subjective. This is the definition of harass from the New York State penal law. It's fine.
Well, I don't agree with that. I think you need a little clearer language than that.
Will you be sending a law to us about taking out the word harassment from all laws in New York State?
Mr. Peter. All right, we're over time.
Thanks, Madam Chair.
Thank you, Mr. Grimm. Sorry to be abrupt here, but
Okay.
yeah, we only have a half hour. Mr. Feeney,
I'll second the motion to move it.
was there a first? Was that you, Mr. Peter?
It was.
All right, thank you. We have a motion for this to go to public hearing. All in favor?
Aye.
Aye. Any opposed? Hearing no opposition. Thank you all, everybody. May I have and Lynn is our prime sponsor on this, so I appreciate those who have also hopped on as additional sponsors.
Oh yeah, can I
Would
be
you-
added
would you
as a
put-
sponsor on this?
Same.
Me too.
All right, thanks, everybody. May I have a motion to adjourn?
So
Motion.
moved.
Thank you, Mr. Peter. Thank you, Mr. Feeney. All in favor?